Hi, and welcome to this latest immigration law conversation. I'm joined once again today by Amie Higgins. Amie, thank you so much for joining me for, I think it's our round two, definitely, for our
It is.
conversations. Today, we're going to talk about a thematic review that the SRA have done in relation to legal services for asylum seekers. And don't shut off if you're OISC regulated. There is some really important advice for anybody doing protection claims that come out of this thematic review. And Amie's done a brilliant free resource as well, and an advice sheet, and I'm going to share the link to that in the description to this video, which if you want to take this further, and if you own a firm or are a consultant, I'd encourage you to go through this in detail, and we'll talk to Amie about how she can help you with that later. But Amie, before we start, tell us a bit about you and what you do.
So for anyone that doesn't know me, I'm an immigration and public law solicitor. And when I'm not practicing, I work as a compliance consultant with DG Legal. So I specialise in all things legal aid related, immigration legal aid in particular. So I help with peer reviews, I help with tenders, I help with any contract compliance issues, help firms individually with any training needs that they have, or drafting precedent templates, file notes, documents, letters, that kind of thing. And just generally on hand to make sure from a compliance perspective with either OISC, SRA or BSB firms that you are doing what you should be doing, and compliant with all their requirements.
No, that's really helpful, Amie. And before we go today, we'll talk about how people can reach out to you if they need help with those things, because in today's regulatory environment, that is so important. But let's start with the sort of big questions. What did the SRA do in this recent review that came out at the end of July into Asylum Legal Services?
So this was the SRA's second thematic review into immigration and asylum. So the first one was back in 2022. And the first one had some fairly damning findings, I think. They were quite concerned with various issues that they found when they'd reviewed files in a number of firms that they had visited. There were issues over how cash payments were being recorded. There were issues over supervision on the files, supervision of staff, the quality of the legal advice being given. And as a consequence of that, they issued a very detailed set of findings in 2022 and said, look, there's no excuse for solicitors and anybody who works within a solicitor's firm for not being aware of this advice that we're giving, the effective supervision guidance, and also this guidance in relation to specifically immigration practitioners. And they warned everybody, look, we're going to come back, we're going to do this again. So read the guidance, read the warnings, and we will be back. We'll be doing a further review in due course. They didn't really say when that would happen. But lo and behold, it took place in 2023, the end of 2023, beginning of 2024, and they've then published these findings in July. So they visited 25 firms, which I believe were selected at random, and they reviewed a total of 64 files. So as part of those interviews that they had with those firms, they spoke to the head of department, so the head of immigration and the overall supervisor of the immigration and asylum work, but also spoke to the caseworkers who were conducting work on the files and any other supervisors as well, just to get a feel of how things actually worked in practice and how the files were run. I think they were quick to proceed with the second thematic review because of the issues we probably have all heard about in 2023, where the SRA issued a very stern warning notice after the newspaper sting with undercover reporters visiting a number of immigration firms where they had posed as asylum seekers and suggested to the solicitors, and the solicitors had suggested to them the possibility of fabricating evidence and fabricating information about a false asylum claim. So the SRA took that really seriously, intervened with a number of firms, took disciplinary action and closed them down, and issued this very serious warning notice in, I think it was November 2023. So they were quick to press on with the second thematic review, I think, really just to make sure that things maybe show signs of improvement since the last one. And I definitely think that the findings that they've released this time around are much less negative, much less critical than they were perhaps in the first one. So that's definitely a good thing. But there are still things that I think people definitely need to know about so that they can have a review of their practices and procedures just to make sure that they are compliant with what the SRA is expecting of them.
No, that's really helpful. You've kind of answered probably my next question as well. You've done the what and the why, and it's good. It's good to see that there was a sort of more positive tone to this review. Definitely
Yeah.
finding that firms largely had robust practices in place. But yeah, can you give us sort of the key findings? What the key findings of the SRA that practitioners need to be aware of?
So they basically split their review into kind of four key themes, if you like. So they looked at engaging with clients and their evidence, effective supervision, ongoing competence, and reporting concerns to the SRA. And kind of within those four key themes, they looked at a variety of different topics. So firstly, they were looking very closely with how individual solicitors and practitioners engage with clients and their evidence. And they looked at how evidence is taken from clients and at what stage of the claim it's taken, the discussions that are had between the solicitor and the client about how that evidence was obtained. And I think the key point in relation to engaging with evidence was that they wanted to ensure that people are cross-referencing evidence, that they are looking at the evidence provided by clients and making sure that it's not inconsistent with evidence that's been provided earlier, and that evidence that's being produced in support of the claim is robust. They did make comments about some concerns that they had in relation to the verification or authentication of evidence. And they felt that there was probably quite a low percentage of people that they spoke to who actually bothered to get an authentication report done from an expert. So I think they said it was just over a third of fee earners would seek to get an authentication report for any documents that were produced in support of a client's claim, and that 64% relied on their own judgment in relation to the experience they had in dealing with similar claims to assess whether something was genuine or not. Obviously, that's a little bit of a concern to some extent because there's a risk that they might make assumptions about the authenticity of that evidence. And the SRA was very keen to point out, look, everything needs to be properly scrutinised, regardless of whether a fee earner has experience in seeing that type of document or evidence before. They really talked a lot about the conversations that are had with the client and the advisor, and at what stage evidence is discussed. So they were very keen to point out that solicitors have a role in terms of advising clients on the type of evidence that would be useful for their claims, rather than kind of waiting for a client to just produce what they have. So having a documented discussion with a client about what would be useful is definitely recommended, because we can't assume that clients know what might be useful to support their types of claim. One of the things that they said that I found particularly interesting, and I think is one of the key points for firms and practitioners to take away, is they talked about this widespread use of WhatsApp to communicate with clients. And I think we can all accept that definitely happens in this day and age. It's an easy way of communicating with clients rather than, sending letters or even emails, because some people don't have access to it or not immediate access. And it was perfectly acceptable that WhatsApp is used as a method of communication, but they were concerned for two reasons, really. Firstly, that if there was just messages in relation to generic administrative communication, arranging an appointment or asking for a document to be provided, then that's one thing. But if there is any evidence of legal advice being provided via WhatsApp, then there's an absolute need for that evidence to be on the file, partly because it is a record of the complete matter, and partly because the supervisor needs to have access to that information in order to have proper and effective supervision of that file. So we haven't really ever seen the SRA talk about WhatsApp as a method of communication before. This is really the first time that they've said anything about it. And although there wasn't any evidence of legal advice being provided via WhatsApp in the sample of files that they looked at, they did say, we recognise that this is something that is happening across the board, and firms really need to think about how that's working in practice, and whether or not firms have got some sort of policy, a written usage policy for fee earners about what they can and can't do on WhatsApp, and how those communications are then stored on the file so that the supervisor has access to it, and that there is a full and complete record of all communications with the client. So definitely a key point to take away is thinking about whether or not you're using WhatsApp and to what extent you're using it, and whether or not there is some sort of policy that you can put in place to make sure there is consistency across the firm in relation to that. Other things they said in relation to engaging with clients was very much about the need to make sure that clients are able to communicate effectively in a language that they fully understand. So the importance of using independent and qualified interpreters wherever possible. And they recognise that, some clients want to use a friend to interpret, or there may be a caseworker within the firm who's able to speak the same language, and obviously that keeps costs down, and there's no reason not to do that as long as the client fully consents to that. They're happy for a friend or family member or caseworker to be interpreting on their behalf. There may be, if you're using a friend to interpret key points where you think actually for the completion of a statement, maybe of an appeal statement, you want to make sure that an independent interpreter is being used, just so that there is absolutely no question of there being any compromise on your independence, and that the client has definitely had, a qualified interpreter, an experienced independent interpreter read everything back to them. The next one they looked at was supervision and effective supervision. So in the previous thematic review, supervision was a really key theme, and they made a lot of comments as to how this needed to be improved. It's definitely suggested within these findings that it's better, but they were concerned that they said only 62% of files that they reviewed had any evidence whatsoever of supervision on them. And what they're saying is very much what they said in the previous review. It's good practice to evidence that supervision has taken place on all files. Now that's easier said than done sometimes, and I appreciate, as a practitioner myself, when you're busy and you're rushing, the fact that you've had a conversation with a colleague about a particular case, or you've asked for advice from a supervisor, you have the conversation, you receive the advice, but then you've got to remember to put that note on the file to evidence that that actually took place. There's often evidence that a file review has taken place, a formal file review, because you'd have a copy of that form on the file itself. But those ad hoc conversations, or the emails that you send to a supervisor or a colleague saying, can I just check this, or this particular client's advised me of this, what should I do? It's really important to try and remember, even if it's just a handwritten scribbled note on the file, put something on there, because it really shows that there is supervision happening on the files. And I do believe with the vast majority of practitioners, supervision is there, it is happening, but it's very difficult to establish that that's the position if there is nothing on the files. Another part of supervision, I think, which is a key part, was that they talked a lot about who is the supervisor, and how do you decide how much to supervise, or what methods of supervision are most appropriate. And they basically said, look, having some form of formalised policies or procedures about that can really help set expectations around how an asylum matter ought to be supervised. So things like how matters are allocated, so depending on a fee earner's experience, skills, competence when allocating files, looking at whether or not you have expectations as to how quickly files are progressed. Should one person be carrying out day-to-day tasks and be the main point of contact, for the client, and then the supervisor would actually take overall responsibility and check all of the work that's being done? Do you have a procedure, perhaps for signing off documents that are drafted by fee earners who are under the supervision of a more experienced solicitor? How are vulnerable clients dealt with? Is there a requirement that caseworkers, solicitors have had significant experience or training in working with vulnerable clients before they are given the responsibility for running their cases? And just making sure that everybody within the organisation has read and is familiar with the SRA's warning notices and guidance, because that's a really good opportunity to refer to those within any policies that you have to make sure that everybody has in fact read them. The next topic really was in relation to continuing competence and the old CPD as it was. they were basically saying, look, we recognise that people are, on the whole, they're doing what they should be doing in terms of continuing competence. And most people can produce a record to say, this is the list of all the training that I've done in the last year, which was great. There was also evidence to show that supervision was taking place through file review, and advice was, being given to individual solicitors as to how they could improve, or noting any training needs through file review issues, and then subsequently booking relevant training courses, which was great. And they also acknowledged that generally on-the-job learning tends to be the most effective way to address any development needs that individuals can have, because of the fact that in this area things change just so unbelievably quickly. They were a bit concerned, I think, that although we could produce a list of training that had taken place, the requirements within the continuing competence was that individual solicitors reflect on their practice. They look at the work that they do, the work that they're likely to be doing in the coming year, and think about what they need to do or what would really help them do their job better. And they very much focused on the fact that a lot of clients that we work with in this area are highly vulnerable or traumatized. And working with vulnerable clients is a pretty niche skill in and of itself, but there weren't really many examples of solicitors having training specifically in dealing with working with vulnerable clients. So not many firms had appreciated the need for their staff to have training in dealing with that kind of vulnerable client and the issues that might bring up. So something to think about in terms of the next year with your continuing competence is really thinking about the type of clients that you work with and how you can perhaps undertake different types of training to enable you to do a better job for them, perhaps. And then the final key theme was, again, another one that cropped up in the previous thematic review, and that was about reporting concerns to the SRA. So again, they wanted to really stress that it's an absolutely fundamental obligation that you must promptly report any matters that could amount to a serious breach of the SRA's standards and regulations. They were concerned that not many people had read the warning notices and guidance, although some had, and some were definitely aware of the key messages, either because they'd read it in the press or they'd heard somebody like me maybe harping on about it in one of our webinars, but they hadn't necessarily gone away and read the full extent of the guidance. So they were concerned in relation to that, and whether or not people really knew how serious this obligation was to report any issues that they identify. Obviously, it's always going to be a matter of judgment whether or not something should be reported to the SRA. And it might be that you receive a file transfer from another provider, and you note when going through the file that actually they failed to do something important for the client, or they've acted in a way which has compromised the client's case or damaged the prospects of success for one reason or another. Where you notice things like that on those files, the SRA really does expect you to report it. And what they said is they're very clear in the findings from this review that where a firm or a solicitor does not report a serious breach when they should have done, the SRA may well take enforcement action against that firm or solicitor. So it's really serious, and the duty to report serious misconduct is clear. It's not subject to any form of client consent or the duty of confidentiality at all. They're saying reporting misconduct is absolutely in the public interest, and it's really important for the SRA to be able to have access to that information so that they can fulfill their regulatory role. So although I've provided a summary, and I'm calling it a summary, it's actually a huge document with a lot of information in there. But as I say, it's broken down into those 4 key themes with the subheadings that I recommend everybody has a really good read of.
That's really helpful, Amie, and it just shows how much there is to think about as individual practitioners, and especially those who are running and managing firms providing asylum services. And what I thought was helpful about your note is that you provided a note, but at the end you provided a sort of table of checklist of actions for firms to take. So I'd encourage you to look at Amie's notes. There was so much that came out. I was jotting down notes there because as I went through the review, this whole thing about sort of reflective I'm going to call it CPD. I'm still used to that language, but thinking about why you need training in something and reflecting on that, and making sure you're making a note of those kind of things. I often get emails and messages saying, Adam, when did I come on that course with you? And because people just wanted that dates of when they want the training, but actually thinking about, well, this case has shown I need some training in handling cases from unaccompanied minors or those with mental health difficulties.
Definitely.
And then the WhatsApp thing, I think, is so important. It jumped out to me when I was going through the review about they cite somebody who uses the desktop version of WhatsApp. So it saves to their firm's cloud, and those WhatsApp conversations can be on the file. Now, you may not do that, but I think, as Amie said, having a policy of how your firm uses WhatsApp. Let's just take a step back. You think of things like how prominent WhatsApp conversations have been in the COVID inquiry. I think people who provide professional services now are using WhatsApp, and this is going to be regulated more and more as we go forward. So I think practitioners need to be aware of that. And this whole thing, what you said about keeping file records of conversations or do something on a case is so important. And then finally, coming back to the beginning of what you said, really interesting about getting documents authenticated. Obviously, there is a tension in the report because the report notes a lot of people choose to go down the private route rather than legal aid. And we know that getting a document expert, is over £1,000, probably closer to £2,000. So, the cost implications to clients of these things. So raises really interesting things. Are there any other, you've covered already some practical steps? Are there any other practical steps you want to leave people with, or sort of things people need to go away and check or review and think about that come out of the review? I appreciate you've given us so much already.
No, that's all right. I mean, I think I'm going to say to everybody, at least read my summary. And even if that is quite hard going, I've tried to break it down so that you can see within each of those key themes what the SRA's expectations are. So the relevant bits of the code of conduct or other pieces of regulatory information that, set out what the SRA expects of you. But at the end of each one, there's some suggested questions, what you need to ask yourself. Think about, for each of those key themes, almost like a checklist. And at the end of my summary note, if we want to call it that, my 18 pages, I've put together a checklist. So if you do nothing else, read the checklist, because that is a way for you to look through a summary of what the SRA is saying you should have in place, and you can review your procedures, have a look at it, and document that you've actually done a review in light of the thematic review findings. So it shows you've read it, or at least read my summary, you've done something about it, and you can make changes if you think that they're appropriate, such as the WhatsApp policy, which is probably a good one to have in place if you haven't got one already, and definitely having another look at supervision and how that's recorded on the file as well.
No, that's really helpful, Amie. If people are watching this and thinking, heck, what do I do? I need help with putting together these sort of procedural documents, policies within a firm, or I need some help in vulnerability training, or what sort of services do you offer? How do people get in touch with you?
All of the above. Any training in relation to safeguarding in particular, working with vulnerable clients, equality and diversity. It's not just me. There's lots of courses out there that I'd really recommend, for people to do as well. If you do need help with drafting policies or even a review of your current practices, or would welcome a conversation as to what you currently do versus what you might be able to do slightly differently to make sure that you are compliant, then absolutely get in touch. You can find me on the DG Legal website and drop me an email anytime. It is just Amie, AMIE, at dglegal.co.uk, and I'm happy to help and have a conversation and see if we can assist in any way.
Brilliant. That's so helpful, Amie. So lots of food for thought there for people in terms of going through the review or going through Amie's note, some practical questions to ask yourself and to review, then thinks of, have I got training needs? Are there things I need to take forward in terms of implementing policies within firms? I'll put the link to Amie's note in the description to this video, and I'll put the link on social media as well. But thank you so much for giving up your time today, Amie, to talk again, but really important information to go forward, because as you said at the beginning, you know, we've seen a trend of these reviews from the SRA now, and I don't think things are going to change at all. This is clearly the direction of travel, and
Yeah.
clearly things that firms need to be aware of.
Absolutely. And I think we all recognise that working in this sector, we feel up against it sometimes. It's an incredibly complex area of law. We're working with, you know, vulnerable clients a lot of the time, and we do tend to get the feeling that everybody's sort of ganging up on us and, you know, or the world's against us sometimes. But actually there are positives to take from this. It is constructive, and I think if you're able to look at it and make some slight tweaks to your practices, it's going to benefit your practice as a whole, your individual staff members, and also ultimately the clients. And at the end of the day, that's what really matters.
Brilliant. Thank you so much, Amie. Really appreciate it.
Pleasure.